Hello. Today's topic is explain the doctrine of lifting the corporate wheel and how far this doctrine ensure protection to third parties. So let's understand what is a corporate wheel. So in English, wheel means a curtain. So corporate wheel means a curtain, right? A curtain between something. So what is that? So this particular concept separates company's action from its shareholders and managers. So this is a just assume it's a curtain which separates actions of company and its partners or managers or shareholders. So this concept treats company and company members separate. So when it comes to company, what is a company? Company is nothing but a separate artificial person, and it's also a separate legal entity. So what corporate will is saying is showing denoting we need to separate. We need to see separately. Company is different, separate, and the members who are part of that company, shareholders particularly, are separate. Now, what is lifting of corporate will? Actually, what happened? The corporate will term, uh, people started misusing the term. So, to prevent that misuse of the corporate structure for fraudulent or unjust purposes, this term came into existence. Like courts proposed this term. Courts say, according to lifting the corporate wheel, under some circumstances, court can lift this curtain and say there is no separation between a company and its shareholders. Whenever a company done something, its shareholders are liable. We'll explain. I mean, I'll explain what is this and what are the ways to do that. So it's a landmark case, Salman versus Salman Company Unlimited. I'll explain that very briefly. Salman is a boots and leather company manufacturer. Boots and leather manufacturer. So what he used to do, he had a small shop, and then suddenly he decided to start his own business. He started this company called Salman and Co. So there were like business was doing great. So 20,000 shares were there. Each share of cost €1, and he divided all the shares with uh, among his family and children. Family means like wife and children. So how he distributed was 20,001 shares he has taken, like majority of portion of it. Only 6 shares he gave to one share to his wife and five remaining five to his children. Now what happened? After some days, he took a loan of €10,000 from a company, a creditor. Let's say he's a creditor. One person gave 10,000 rupees for for the development of the company. Please understand, he has taken a loan for the development of the company without any surety. That is debenture. So this is very important. And later what happened? After some time, he ran into some losses. So he wanted to do the liquidification. So that is like closing the company and you know paying back all the credits or debts. So what happened? The creditor filed a case in the court of law saying this guy Salman is not paying the money. Then Salman responded to the court saying this company, Salman and Co., is a legal entity. It's a company. So he used corporate will. There is a separation between company and its shareholders, directors. So he used that. But what court said was, so court immediately I understood. Okay, he's doing this to prevent or he's doing this to misuse the corporate will concept here. So court have this authority, power to lift it. Let's see that. So these are the circumstances for lifting the corporate will. Okay, finally, what happened in that case? Judges court ordered Solomon to repay the money to the creditor, even though he's mentioned like there are like six more persons, they are also liable to pay back the money of €10,000 to the creditor. But court said no, no, they even though they are members of the company, they are just sleeping partners and they did not contribute much to the organization company's growth. So Solomon is the only person who is supposed to pay back the money. So that's what the court said in this said above case. Now see the circumstances of lifting the corporate will. So fraud or improper conduct. If any company had started doing fraudulent activities or improper conduct, what courts can do, they can lift the corporate will. And the second thing is evasion of legal obligations. If there are any legal obligations and the company started to prevent or to avoid those legal obligations, so in that cases also court can lift the corporate will and make the shareholders liable for the acts committed by them. And third one is agency or alter ego. When there are like three or more companies formed like an agent, and that agent is another company. In that cases also, corporate will can be lifted, and finally the public interest. So courts can lift corporate will to safeguard the public interests. Now, so protection of third parties, right? Protection to third parties, right? So this doctrine, lifting the corporate will, definitely serves as a protective mechanism by ensuring they are not unfairly prejudiced by misuse of the corporate form. So people, when company makes any misuse or fraudulent activity on behalf of the company name, and finally they come up with corporate will concept to separate legal personality. So these things can be actually create a lot of problems to the third parties. So with this lifting or piercing of corporate wheel, third parties can definitely help us. Thank you.